welcome to Legally Speaking with me, Tarun Nangia. For the first time in a long time, we have a Chief Justice of India in the form of Justice N.V. Ramana, who had spoken extensively on the need for judicial infrastructure. And he also spoke of the funds that would be required and his intent in doing these things. Of course, judicial infrastructure not only include courts, but digital infrastructure. And that is where our topic stems from today, that for the High Courts and the Supreme Court, only for the High Courts and the Supreme Court, what kind of digital plus physical hearing mechanisms we need to evolve, which is called in effect a hybrid court. So what is the hybrid mechanism that we need to evolve? Because three people should benefit. A, the client should benefit, in the litigant should benefit. Second, it is the lawyer whose time should be optimized. And it is also the judge whose time should be optimized. How these three things can synergize to benefit the whole legal ecosystem is what we are going to discuss today. Some very good suggestions I'm hoping from our esteemed panel today that, of course, the judiciary may consider when it is forming, in a sense, a plan to formalize the hybrid litigation concept where courts will work both in the digital mode as well as the physical mode. May I introduce you to my panel today? I have with me Senior Advocate Parag Tripathi. I have with me Senior Advocate Rajiv Nair. I have with me Senior Advocate Amit Desai. He joins us from Bombay. My previous two panelists are from the city of Delhi. I have with me Ryan Karanjawala, Managing Partner of Karanjawala and Company, one of India's leading litigation law firms. I have with me a new entrant to the Legally Speaking Club this time is Mohit Saraf. He's launched his firm called Saraf and Partners with a bang, 110 lawyers, I heard. Many congratulations to you. 22 or 23 partners is what I heard. So that's a great start and welcome and many congratulations and best wishes to you. So let us get on with the topic. May I get in Senior Advocate Rajiv Nair to open the discussion? How would you balance physical and digital hearings? How would you balance it? What would you like to tell to the whole legal ecosystem? What is good for us?
Tarun, it's very difficult because, on the one side is this populist sentiment echoed by these politicians in disguise, as I call them, the representatives of the Bar Association, who are insisting on this physical hearings without there being any infrastructure to facilitate the same. Now, for instance, please look at the Delhi High Court. At the moment, they are restricted to urgent matters 2021 and 2020. And just visualize what will happen supposing the entire court becomes physical for all matters. So the court is certainly not equipped, even the judges are not equipped to meet this kind of influx of people. Because even if you restrict by an advocate each, a clerk, a junior advocate, with about 30 or 40 matters multiplying into 80 or 90, if you open the entire list, then where is this infrastructure available? So for the time being, we know we are in the grip of a pandemic, which will soon turn out into an endemic, as experts are saying. And we are looking at a horizon of 6 to 8 months, hopefully. There's nothing wrong with permitting hybrid hearings, or there's nothing wrong in permitting virtual hearings for those who want to avail of that facility. Actually, I just want to tell you that Chief Justice Bobade, as he then was, in a petition which went from the Delhi High Court to facilitate hybrid hearings, made a very telling comment. And, I always, remember that remark, because he says no lawyer or a litigant should be compelled to attend a court physically. It's a choice which can be voluntary because, for instance, Amit may decide his client may insist on his going physically in a particular matter. So that's for Amit to take a call whether he'll go physically or virtually. But you can't tell Amit to say, no, you must go physically in all your cases every day. So in this pandemic, you can't force a lawyer or a litigant to physically go to every court. You must give him that option. And later in the program, as we'll outline, I will also keep you abreast of a very good order which has been passed in a division bench by a division bench of our Court of Justice Sanghi, where he is insisting on hybrid of the entire district courts.
Oh, that will be interesting to know from you in the course of the discussions.
Yes, I want to, and I'll elucidate that order, because he has asked for a status report and the expenditure is about 227 crores. And the Delhi government said, we don't have the money. Then he said, if you don't have the money, please give me the particulars of all the money you spent on advertisements, etc. So that I must know that where you have been spending your money. So that's another way of enforcing it. But what is significant is that courts are looking at virtual in the long run. I think it's not going to be in a short term. If you are asking the entire district court to be hybrid, then at least the Delhi High Court or the Delhi is looking at a hybrid model in the long run. I think that's something which we have to, should be the core of your program, that what is wrong with looking at hybrid on a long-term basis.
Point very well taken. I'll now go across to Senior Advocate Parag Tripathi. So we saw what the Chief Justice of India said. Now, how do you see this evolving? Do you have any suggestions to give for the hybrid mechanism? Because I was interacting with a bunch of young lawyers last week from Bombay, and they said, I don't want to fly to Delhi to take an adjournment. Admission final hearing is fine. But why should I fly to Delhi for an adjournment? How would you see this predicament of the whole legal community?
Tarun, just to correct you, you're still talking to a bunch of youngish lawyers even now. That's one. But coming to the question which you raised, I think that's important. We have to remember two things. One, technology or new technology is by nature disruptive. It disrupts your way of thinking, your way of doing business, your way of going about things. So there's an element of disruption there, which is unsettling for everybody. Two, and that's important, when we look at this virtual hearing, there are two focuses we have to have, the telescope and the microscope. The telescope is the long-term view which you have to take, because this is the only way you will be able to have a justice delivery system which will reach the grassroots. The other method is simply not working. That's, of course, the telescope. The microscope is the current scenario, which Rajiv very rightly pointed out, because of COVID, where we have, if I may use the expression, we have a pandemic in waiting. It hopefully will not come again, but you never know. Now, in this background, I don't think there is really an option. We have to go for a hybrid hearing. Ideally, it would have been virtual, but as you know, as our Chief Justice has also said, and judges before him have also said, that there is a technology divide in our society, not only amongst litigants, but also amongst lawyers. And that technology divide hurts. Rajiv again referred to it in the context of how the bar keeps on saying have physical hearing. But at the base of that is this very genuine reality of a technology divide. I think my personal view is sooner or later, the courts will read a virtual hearing or hybrid technology in court as part of Article 21, because it has all the elements which you are looking for in Article 21. The problem is you have to have the enabling technology. That's very important. So you have to have the core enabling technology. And this is not sequential, that you first develop the technology and then you do it. You have to do it as you progress. It's like a lawyer's career. While you make errors and learn, you still get paid and function as a lawyer. That's perhaps the only profession where you get paid to make mistakes. The same way.
Tripathi, if I may interrupt you, before I go to Senior Advocate Amit Desai. You have a bunch of high profile clients and you argue cases in a single day in Supreme Court, National Company Law Tribunal, and the Delhi High Court. Now you physically go from each court to the other to argue the matter. Now, in case it's not an admission or a final hearing, would you prefer to sit in your chamber and argue the matter?
I think any lawyer, given a basic good level of technology or technology platform which is available in the court and who has the wherewithal, is bound to prefer virtual hearing because of the great advantage which it gives you, both in terms of time spent, in terms of the ability to focus and prepare. I think it's a no-brainer. The problem arises when the technology platform is not good enough and or the lawyer does not have the wherewithal to have the benefit of the latest tools of entering.
That's a fair point. That's a fair point. Senior advocate Amit Desai joins us from Bombay. Sir, if I may ask you, what do you feel about this whole issue? Because for you also, I mean, High Court is fine, but for Supreme Court, you also have to fly down all the time. How would you see, how should the High Courts address this issue of hybrid courts, and how should the Supreme Court address it?
So Tarun, it's interesting and it's ironical as to what's happening in today's time. If you go back to the last 10, 15, 20 years of what the direction the Supreme Court has taken in relation to ongoing normal litigations, they probably about 15 years ago settled the principle that evidence can be recorded through video conferencing in Praful Desai's case. It was a path-breaking judgment in the context of the way in which typically litigation is dealt with here. We then had the Supreme Court talk about service of summons through WhatsApp and emails. The Supreme Court has always embraced technology as part of the ongoing process. Today, yes, we are at that stage where the question that arises, do we embrace the technology of video conference hearings? And the issue for us really is that how do you balance the constitutional needs and the needs of the profession and the litigant, which is rightly pointed out. What is ironical in today's time, as Rajiv pointed out and what you have said, is that the younger generation who is born with technology in their mouths are resisting the use of technology. And it is the seniors like us who have very little understanding of technology who are actually asking for this technology to be the way forward for use in these court hearings. Now, when you look at it from a constitutional perspective, you have a fundamental right to access to justice. The process in the context of the pandemic is that technology gives the access to justice because the litigant, wherever the litigant is, has the choice to come in through technology into a court hearing and hear his matter. He has the choice to participate in the High Court or in the Supreme Court if he does not wish to travel. You have a second legal right, which is a right to choose your lawyer. Now, when it comes to the choice of the lawyer, as Rajiv and Parag pointed out, if you say that I want Rajiv or Parag as my counsel, but they say we are not coming into the physical court, then how does the litigant have the choice of his lawyer? He has the choice of his lawyer because that lawyer will appear through the VC and or a hybrid hearing. So what you're doing essentially through means of this technology is you're also fulfilling various constitutional needs. The challenge is about the technology platform and some amount of figuring out as to how do you deal with the roster and how do you balance the needs of the generation which wants to come into the physical court and the generation which wants to use the VC. I think that's a matter of some SOPs that can be worked out by the courts. I think it's a matter of ensuring that there's a fair platform for which courts can provide, the government can provide the necessary wherewithals. And then it's a question of providing the equipment to the younger generation. As Parag rightly said, we are in a disruptive mode. It's not just the legal profession which is being disrupted. Every aspect of life today is being disrupted. Look at businesses, they are being disrupted. Look at the unorganized sector, they are being disrupted. So disruption there is chaos today, but that disruption will bring about significant changes which are relevant for the next 30, 40, 50 years. And that disruption means the providing of technical support to the youngsters or those who don't have the equipment to run through a VC hearing.
Point well taken. When you said equipment, I remember Justice Ramana talking of infrastructure and equipment. I think there is some good news that we all will hear from the Supreme Court, but let's keep our fingers crossed. Mr. Karanjawala, you will engage lawyers, some to appear outstation. For them also, it's good. They sit in Delhi and argue matters in Calcutta, Bombay, wherever. But secondly, just for the High Court and Supreme Court, what mechanism will be best that amalgamates the best features of the physical mode of appearance and the digital mode of appearance?
So, Tarun, I'm predicating this whole argument on the premise that we are talking of an era when the COVID has receded or has abated or has disappeared. So
Yes.
let's ask ourselves the question, all right, today we no longer have to worry about stepping physically into court. What would be the best way for the courts to deal with the situation in future? Now, fortunately, at the moment, I find that we have at the helm of the Supreme Court a Chief Justice who is busy trying to push the envelope to find ways in which he can maximize the output that a court can give.
Yes.
And therefore, I feel this is the right time to look at a hybrid hearing along with a physical hearing. You see, the minute COVID recedes and people want to come to court, and those lawyers who want to come to court and argue in person, they should be allowed to do so. Because you can't prevent people and say, no, let's stick to the technology. Let those who want to argue in real time, argue in real time. At the same time, you have to remember that the Supreme Court, for example, is a court of different geographies. And the advantage of the visual hearing or the virtual hearing, as I've said in the past, is simply this, that geography becomes history. The advantage of virtual hearing is that a person from Bangalore or a person from Bombay can address the Supreme Court as easily as a person standing physically before that court can do. Now, is this an advantage that we should just give away merely because COVID is over? Is the question that we have to ask ourselves. So I would in fact think that the one or two ways the court can look at it is say, all right, 10% of our time we put to only virtual. So on a particular Friday every 2 weeks, the full court sits in virtual mode and they put all matters on board where people from out of town want to come in and argue. So on that day, the litigant who is out of town can brief his lawyer out of town without having to incur the huge cost of coming all the way to Delhi, suddenly finding the matter adjourned and flying all the way back. The other area where I think virtual hearing should be absolutely necessary is not virtual hearing, but virtual viewing. As far as litigants are concerned, one should organize a system by which, wherever they are in whichever part of the country, they can just log on and see what is happening when their item is going on. So that a large part of the difficulty that the litigant has, having to leave his job, come down physically, and so on, abates. As far as hybrid is concerned, if we find that the hybrid system is working, and this will be an experimental mode, you'll have a situation where people are happy to come to court. But there will still be people who want to say, but my lawyer wants to argue from Bombay, and I don't want to have the expense of bringing him all the way down. If in such a situation you can have a hybrid hearing, and I'm told that that is happening in some of the high courts, where one side can argue in real time, physically standing before the judge, the other side comes on a screen and puts his case across. Then this is something that should be experimented with and see how efficiently the court is able to cope with it. There's absolutely no doubt that every court should do its best and endeavor its best to maximize its resources to ensure that its infrastructure is built up. I had once said in one of your programs on Tarun that, in India, we have a system of never awarding heavy costs. Everybody, the usual answer is no cost at all. Maybe you can set a technical court fund up and the courts can keep awarding costs from one side or the other, whoever loses the case, which goes into this technical fund, which keeps on improving the infrastructure of the courts. So this is something that is certainly something we should look at, we should think through, and whether or not we have virtual, only physical or hybrid is something that we should constantly experiment with till we come to a happy means.
Okay, point well taken. One, you could be a script writer because of the line "geography becomes history." That's
No,
one.
it wasn't mine. It was a quote for the satellite phone when it first came, called Iridium. They advertised saying geography becomes history.
Okay. And the second is, of course, the point that you made on the cost to be imposed. I'll go to Mr. Mohit Saraf. Mr. Saraf, can we have a model where the judges, litigants, and the lawyers are all happy?
Absolutely. I think, in my view, this is a very basic thing, that access to justice should be available to everybody. And I think we all understand there are real battles. I worked with Fiki on presenting a judicial reform paper for the Prime Minister's. And I realized we investigated, one of the big issues was appointment of judges. But not a small issue was infrastructure, physical infrastructure. And right now, whatever said and done, we actually, in last year, we were virtually, everybody was physical. And now we are all virtual. And an opportunity has come, and we basically have functioned in that opportunity. Now we should not give up this game. That is a very important part, because I think lawyers can be effective, clients can be more effective, everybody can be effective. But what we need to look at is, how do we improve the system? Like e-cost, e-filing, e-service, all these things have to be improved. And also, I think one important comment which Mr. Desai made, that youngsters are opposing. And I think we have to look at it we are all seniors. We need to think about is, why are they opposing? Because really, if you look at globally, because of pandemic, rich has become richer and poor has become poorer. That is a fact. Because people who are serious, senior, and who are well known are able to muster larger market share, whether it's an Amazon, whether it's Netflix. And therefore, people who are at the bottom are losing the market. And therefore, it is very important for all of us to think about an enabling environment where our youngsters can also, because right now, Mr. Nair can be all over the country, which he was earlier could not have been. And that is a big problem, where our youngsters are feeling that they have no opportunity left now with this virtual. And it's not an unfair thing. And one important part is that we have to make sure that technology, they're educated, like Mr. Tripathi said, that they need to understand technology and they should be very comfortable dealing with technology. That is one part of it. The other part is that we all seniors have to create a little bit more enabling environment for people who are not tech savvy, because we all have become tech savvy in last 1 year. That we give them opportunity, even sometimes their phones are not new, they've done a mistake. We don't look down on them. We give them, because to being on virtual and to handle physical file is a very challenging time. And therefore, I think a lot of these things are actually a requirement where there are insecurities. I think I would say, I will not call it politics at the bar. I'll call it insecurity at the bar. Remember when the government was trying to open up the market to foreign lawyers, everybody was up in the arm. Not that they were insecure, but they just thought they'd lose the market. Same is the issue here. So I think it's an important thing that we need to understand this issue well, and we have to find a right solution which works for everybody, so that actually at the end, rich should not become richer. I think that's an important part.
So basically, you sort of more allocation in terms of resources for other lawyers who are growing up, some sort of an arrangement.
And also, I think the balance, I think what is important is, one is technology, one is an opportunity, one is also judges have to understand that these are people who are actually joining from outside people, co-counsel have to do, so that they all start feeling comfortable. They don't feel that they have lost the advantage.
Okay. Point very well taken. Mr. Nair, should the roster that the Chief Justice, in a sense, makes in either the High Courts or the Supreme Court account for that every judge sitting should allocate at least 2 days in a week or lesser or more to digital hearings? Can this be done in your view, in your experience?
Well, so, Tarun, we have to step back a bit, like Ryan pertinently said, that what will happen post the pandemic. So at the moment, you see, with the number of cases going down, I mean, not the number of judicial cases, but number of COVID cases going down, schools are reopening, cinema halls are reopening, then it's very well unjustified for somebody to say, why only the courts are an exception? Why should only the lawyers remain virtual when everything else, including schools, which is, I mean, you have children of class 8, 9, 7 going to school. And if you've seen the statistics, children from government schools in Delhi, there's an attendance of almost 80% as against 10 or 20% in private schools. So obviously, as Mohit said, this is also a bit of a class divide. But be that as it may, in the with the possible receding of a third wave, we don't know, it'll come and go. It'll become increasingly difficult for everybody lawyers to insist that we should remain virtual. Now, going forward, this arrangement is primarily intended to facilitate the COVID transition. I don't think anybody is looking at it at a long-term solution. Parag mentioned about a fundamental right of Article 21. Supreme Court just issued notice, and all the judges I read were actually vehement in saying that there must be physical hearings. You know, we've all been brought up in this fashion of having physical hearings. I mean, Amit was not used to technology. I was not used to technology. Perforce, we had to get ourselves used to it. But, you know, we were used to physical courts, doing a few cases, having a cup of coffee. You know, it has its own charm. So we can't say that the physical courts don't have advantages. They have their own charm, because life in a lawyer, for a lawyer, is not only just appearing from his bedroom. It's many other things. I mean, he's meeting people, he's meeting clients. There's a vast diversity in that. But I think that we are really far away from establishing hybrid as a mechanism of addressing courts. And believe me, once this pandemic ends, everybody will be in courts physically. Nobody will even remember hybrid hearings. As it is in Delhi High Court, lots of judges are saying, we are not used to hybrid because we have to look at you physically and I have to look right and left for the person virtual. So post the pandemic, I don't see it as a long-term measure.
Okay.
Somewhere down the line, I think hybrid hearings will just collapse and it'll only remain for this transient period, maybe a couple of months more, if at all it remains. Amit will tell you this, his entire court has almost become physical. All high courts, many of them have become physical. It's only Supreme Court, Delhi and all, which are still hybrid. There is, of course, Karnataka.
Point very well taken. I'll quickly go to Senior Advocate Parag Tripathi. On the judiciary side, are we giving them the option? I mean, lawyers appearing digitally are all okay, but can a roster be made where judges are also allowed to work from their camp office or their residence office, and they also work digitally? It can't always be for the lawyers. Should this facility be extended to the judges also as senior member of the bar? What do you think?
Absolutely. I have actually said so more than once in your show that it can't be just that a lawyer or a litigant has this choice. This choice, first of all, has to be for the judges. And there is also an added issue of the registry, because registry is often left with no choice. So surely this is an area which requires serious consideration. And I think Rajiv does raise a very important point that will we go back to the square one, as they say, once the fear of COVID subsides? I hope not, because I think there is a lot to be said for this technology, but it needs a tremendous amount of improvement, which will only happen if we stick on to it. What I said, that you need to have that view from the microscope to the telescope. Rajiv referred to that very interesting judgment and orders passed by a division bench, which is there in the, it's called the Anil Kumar Hajele case. And now the last order was of 6th of September, where there was a direction to the GNCTD to find out about tribunals, etc., and how best it can be seen that you will have that hybrid way of dealing with matters. And now the next date is 5th of October. So I think that will be before we have another meeting of your group here, and maybe something really positive will come out. There's one interesting thing, initiative taken by the Chief Justice's Court in the Supreme Court, suo motu, which is this FASTER scheme. Now, FASTER stands for Fast and Secure Transmission of Electronic Records. And this was kick-started because there was a newspaper report which said that juveniles were serving 14 to 22-year terms in Agra jail, and despite court's order were not released. So These are various other smaller things which can happen in any way, whether you have hybrid hearing or not. But I think in the long run, we have to look at and be ready to embrace with superior technology a hybrid hearing, which will work particularly when you have huge matters. Like, for instance, you have several of these home buyer matters in the Supreme Court, where on a working day, you'll have 300-400 people waiting outside the courtroom. It's impossible to handle it physically. So I think there is a future for hybrid, but yes, it's a cautious view of future. And I hope that the technological breakthrough will help us through here.
Sorry, Tarun, I'm sorry, I'm intruding on Amit just before he responds. I just wanted to add this insecurity of younger lawyers of physical, as Mohit pointed out. There's no question of insecurity. It's not as if that Amit's cases will come to me or mine will go to Amit just because both of us are on a different platform, physical, virtual. The client will insist on, if it's it's a smaller case, one particular lawyer, bigger case, some other lawyer. So nobody is snatching away cases, or no case will go because you aren't addressing it either virtually or physically. This is a misnomer.
Okay. Mr. Amit Desai at this point, Senior Advocate Amit Desai.
Tarun, I think the question really is only one of choice. I don't think the issue before us here is whether it should be only VC or only physical. The question is only of choice, and the choice should be available to the litigant, should be available to the young lawyer, should be available to the senior lawyer, it should be available to the judges, it should be available to the system as a whole. The question really is, are you making that choice available? And as Ryan initially pointed out, one of the realities which is Ryan and Mohit as solicitors who interact with clients recognize on a day-to-day basis is that there is a very huge cost to litigation. And a video hearing or a hybrid hearing has the ability to reduce the cost of litigation. Therefore, as Mohit's point is, one, of course, the younger generation of lawyers are to be protected. In fact, as we all grew up, and I remember, we actually came into the physical courts to see our seniors and the legends of the bar at that time and learned advocacy from them. That is one problem that is getting missed out in this whole thing, that the youngsters who are the future of the litigation, the judiciary, because ultimately the judiciary is drawn from the younger lawyers, litigating lawyers. They are missing out some of these things. So you do need them. Now the question is, you need them in the physical court, or you can also give them access in the virtual court so that they can see seniors. But there is one other problem which I think Mohit rightly pointed, and we see this at least in Bombay. There are youngsters who get walk-in clients, so they're sitting in the library of the court. And I do see that in the Bombay High Court, really, when you go to the appellate side or some, there are young lawyers who get from the districts, the clients come in or advocates come in, and they are some kind of walk-in clients. They lose that opportunity. So the question is only one of choice. I don't think the question is about forcing anybody to go this way or that way. And I think the need, as Parag rightly said, the telescopic view is that there is a need for embracing this technology in the court system, because there are lots of matters, smaller matters, admission matters, routine matters, which can be dealt with through a VC hearing or a hybrid hearing. So you're taking away a significant burden of the litigant or the lawyer when they're dealing with these smaller matters. Let me just momentarily deal with the other question of the roster. I think when Ryan suggested that maybe, you should think about having every 2 weeks, the entire court sitting on a VC hearing. My own sense is that may not do justice to the litigant and to the counsel, because that means that he has to wait his turn for a VC date. And I think that itself has its challenges. What is happening in the Bombay High Court today is that every court with every roster has one VC day. So they have their opportunity within a week, whoever wants to come in. We are told that from next month, they're now trying to introduce a hybrid. So hopefully now we don't have a single VC day, we will have hybrid. And once it's hybrid, then there's a choice of the lawyer to come in or the litigant to come in. So if that happens, then you will have normal cases coming up more regularly for hearing on a regular basis, because today we're only dealing with urgent matters. All the old matters are buried in the system. A lot of that will start up and courts will come back to normal functioning much faster, because hybrid will make that happen. If we keep living in the fear of COVID, then we are seeing this problem of litigants suffering because all their cases which are pending in the courts not being taken up for hearing for another 6 to 8 months. and they've suffered a lot already.
Point very well taken. We now go on for our final two comments. Very quickly, Mr. Karanjawala, opportunity to appear digitally as per the roster at least 2 days a week. I mean, every judge, he also then should have the opportunity to sit at his home and conduct the court. Not that he comes to the court and all lawyers appear digitally. Is this a workable model?
So, Tarun, while this show was going on, one other thought occurred to me, and I'll share it with all of you, which is this, that one thing where virtual hearings can go very well, and to take your point further, is the vacation court. For example, the Supreme Court has a large chunk of time when it's on vacation in the summer holidays, then during the pujas, then during a week in Diwali, and then again the Christmas holidays. So if you add it all together, you might have almost 2.5, 3 months where the Supreme Court sits in different chunks as a vacation court. Now, the problem with the vacation court is that you then have to assign and get 4 or 5 judges who choose to stay in Delhi in order to man what is known as the vacation benches. This technology can very well come to the rescue of the courts during vacation time. So instead of having only 4 judges sitting and 2 separate benches sitting during the vacation court, you could, taking your point further, which is different judges functioning from their residence into different courts, you could have many more vacation courts and much more disposal during the vacations than otherwise. So a judge need not a judge doesn't have to take the whole vacation. He can say, all right, I will be in my hometown. I won't be in Delhi. But for these 5 days, I'll be available to work virtually. And obviously all the papers will be flown to them and so on. And every place has its own sort of makeshift infrastructure, which the judge gets to use while he's on vacation. So suddenly vacation time itself can be put much more usefully, and many more cases disposed of than normal if you avail of this virtual system.
Point taken. This can be a flexi working, as they say. One final comment from Mr. Mohit Saraf. Judges also being given the opportunity, and the roster also providing that 2 days a week, judges will accept lawyers to appear digitally. Not every day, but at least 2 days a week. How does this work? Can this work?
I think one important part is that whatever we have learned in a crisis over last 1 year, we should not give up. And
Yes.
I think that option should be available to each one of us going forward. I think that is something which is that is actually determined to bring efficiency in the system, number one. Number two, also works for the larger good. Because really today, even if the Chief Justice gets few judges appointed, where do we have the infrastructure, the physical infrastructure? So that is required even under Article 921. So I think that we should not make it a temporary measure. Otherwise, all benefit is lost. But what we need to think about is what are the key learnings? How can we do it as a hybrid model going forward on a long-term basis? Because that is the only way. Like today, I think the government has realized that we can't have access to banks to the entire country. And they are trying to support fintech companies. Same thing we have to understand it, that if we want everybody to have access to justice, this is an important technology enabler. We should allow that to continue. We need to also plug in the problems of youngsters, technology problem. Like a lot of clients tell that these virtual hearings are very expensive. Earlier, we used to only fly lawyers. Now we pay for ineffective hearings. Earlier, there will be very little ineffective hearings. Today, there are many more ineffective hearings. Because the arguments, because when you are in the court, you look at the body language of the judge, you understand he's not listening. So you cut your arguments. But if you're on a virtual, you can do whatever it takes. So a thing which takes 4 hearings takes 10 hearings. So what sometimes a client has said, Mohit, what you're saying is right, but travel cost is only a small problem. The problem is lawyer's fee, the arbitration panel fee, and that is exceptionally high because we have multiple more hearings. And it is so easy to come in and get adjourned and then come for 5 minutes and then move on. And I think that is again a part. And again, this is something which also we need to improve because eventually we should not give up. the learnings of last 1 year. I think in my view, I never believed this can happen. I remember I did a conference for FICCI on how to handle crisis out of COVID within 1 year, within 7 days of COVID. And there were 1,500 people, 1,500 corporate on a Zoom call. I never thought that this is possible. And they were there for 3 hours. And that is the reason I'm saying this is a technology which I would have never paid attention to because I'm just not savvy. And today, by crisis, we have all savvy. And we should not give it up and saying now things are normal, because this helps us to get access to justice to a lot of people. Today, a lot of people cannot do that. Even small lawyers. Today, if let's assume you have a litigant from Bihar, and he says, I can't afford somebody in Delhi, but I can afford a neighbor of mine at a Supreme Court, and I want this thing to happen. He at least have an access. And therefore, let's not take that thing away. And I think we have to build checks and balance so that every interest groups, because I think any solution works when you fix the legitimate interest of different groups. As long as you do that, I think in my view, it's a win-win for all three stakeholders. As you
point very well taken. As you said, saw Mr. Mohit Saraf echoed the oft-repeated statement in governance in India that you never waste a good crisis. Use the crisis to benefit. I would like to thank Mr. Mohit Saraf, Senior Advocate Parag Tripathi, Senior Advocate Amit Desai, Ryan Karanjawala, Managing Partner from Karanjawala and Company, Senior Advocate Rajiv Nair, all of them for sparing time at a short notice and contributing so much to this discussion. I hope these deliberations will be useful to our viewers, also to the larger legal community, who I am sure they are in their own way, including Chief Justice of India, Justice Ramana, thinking and mulling over how to take this forward. It's very challenging for them more than us because they are deciding. So whatever they do, they will be blamed for it. I don't think in India praise comes easy. So let us see what they do. We are earnestly looking up to them. Thank you so much, all of you, for joining me. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.